Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So, I haven't been covering the Blake Lively, Justin Baldoni lawsuit in a little bit, and that's mostly because covering it made me realize that I kind of hate both sides, and really just the way Hollywood seems to work. But there's been an update that did interest me, and I wanted to cover it, and this is with respect to Andy Signor of Popcorn Planet. Now, he's just put out a press release. Let's go and have a look at that. So it says, for immediate release, Florida judge rules against independent journalism for celebrity Blake Lively. Now, I'm going to have some thoughts about this, and we're going to go through the entire decision, but let's look at what they have to say first. So, in a ruling that has alarmed digital media experts and First Amendment advocates, a federal magistrate judge in the Middle District of Florida has denied journalist protections to Andy Signor, founder of the independent news network Popcorn Planet. Note the use of news network here. There's a reason for that. Solely because his reporting appears on YouTube rather than in traditional corporate media. Solely is doing a lot of work here, and you can judge for yourself if that's really a thing here. So, Judge Lindsay S. Griffin ruled that Signor, despite hosting a daily investigative news platform with nearly 1 million subscribers, does not qualify as a journalist under Florida's reporter's privilege statute. As a result, he's been ordered to turn over private communications with sources related to the high-profile Blake Lively versus Justin Baldoni legal case, communications shared in confidence by whistleblowers fearing retaliation in Hollywood. This ruling is a chilling attack on independent journalism, Signor said. It suggests that unless you work for a newspaper or legacy media corporation, you have no right to protect your sources. That is not only wrong, it endangers every whistleblower, content creator, podcaster, and independent reporter working today. Hey, that's me, right? So, yeah, just keep in mind, I would fall into the content creator, podcaster, independent reporter category, right? Throughout the case, the magistrate judge accepted sealed claims from Lively's legal team at face value while dismissing Signor's sworn testimony. By doing so, the court effectively created a two-tiered system of press rights, one for corporate media, one for independent journalists who operate on modern platforms such as YouTube, podcasts, or online publications. Legal analysts warn that if allowed to stand, this ruling could erode long-established reporter protections and discourage insiders from coming forward, particularly in industries like entertainment, where pressure and retaliation are common. One thing we've seen from this lawsuit so far is that Hollywood is basically a nest of rats. So, Signor's legal team is preparing to appeal directly to the U.S. Court of Appeal for the 11th Circuit, bypassing further proceedings in the Middle District of Florida. A petition to the U.S. Supreme Court remains possible depending on the outcome. Independent journalism is not the fringe, it is the future, Signor added. Millions rely on digital reporters for honest coverage that isn't filtered through studios, publicists, or corporate interests. I would agree with this. We saw a real discrepancy in the Johnny Depp trial between sort of official corporate legacy media that very much seemed to go with like the PR from the Heard team versus independent media who were able to like look at the actual filings and so forth and came to very different conclusions. So, if the courts erase our protections, powerful people will be able to silence inconvenient reporting with a single subpoena. So, to support the appeal, Signor has launched a new public campaign to raise a legal war chest for what will be a significant and costly fight to defend the rights of modern journalists. And there we go. He's got his Give, Send, Go, and he notes about Popcorn Planet. Popcorn Planet is a rapidly growing independent news network on YouTube with nearly 1 million subscribers, focusing on investigative reporting, legal analysis, and entertainment industry accountability. The platform hosts attorneys, experts, and insiders, and is producing the upcoming documentary It Ends with Justice. Okay, so there's a reason for all of the talking about it being an independent news network. And that's going to be in the decision. So let's have a look at the decision, because some of the things in the decision I disagree with, but I also kind of disagree with Mr. Signor's characterization of things. I just wanted to interject here a little bit to note that I don't think that Mr. Signor's discrepancies between his characterization of things and the court's ruling are because of maliciousness, just so much as what he's focusing on. And that's reasonable. I also don't take issue with him fundraising because there are some real issues here in terms of press and who counts as press and so forth. And I very much do hope he appeals this and that the appeal goes his way. I will also note that there are some substantial differences between sort of his description of what goes down versus the court's description of what goes down. And I really hope there's an appeal so that I can cover those documents and sort of say, hey, look, here's the other side of things in a more fulsome way. So we're going to cover what the court says in their order. But again, I'm not suggesting that there's anything malicious here. I'm just noting there's a difference. There's a distinction here between sort of his version of events and the court's version of events. And it doesn't mean that the court's right. So anyway, on we go. So let's break it down. Okay, so here we go. United States District Court, Middle District of Florida, Tampa Division. So order. Under Rule 45D3, Federal Rules of Civil Procedure, Popcorn Planet moves to quash a subpoena for documents served by Blake Lively, who responds in opposition. So what happened here is that Blake Lively wanted some documents from Popcorn Planet. She served a subpoena, and they said, we don't want to comply with this. We want to shut this down. So that's sort of what this is about, right? Can Popcorn Planet shut down that subpoena, or do they have to comply with it? Because Popcorn Planet fails to establish that the privilege applies, or otherwise waive that privilege, and fails to demonstrate an undue burden, the amended motion to quash is denied. Now keep in mind, they said that the sole reason why this was denied was because it's a YouTube channel, and that we're already seeing multiple reasons, right? So let's break this down a little further. We're going to go through this. It's 18 pages, so this will be a little bit of a lengthier video, but that's what we're here for, right? So background, this matter relates to Lively versus Waiver Studios, which is pending in the Southern District of New York. Lively sued in December 2024 and alleged that during production of the film It Ends With Us, she experienced sexual harassment and an organized campaign of retaliation led by her co-star Justin Baldoni. According to the complaint, Baldoni engaged crisis manager Melissa Nathan to help Baldoni get ahead of the narrative and mitigate bad press generated by Lively's complaints. The strategy allegedly included third-party advocates willing to provide a potential quote or engage with reporters on behalf of Baldoni and others, and the seeding of content on traditional and social media platforms. I should note, I have had no contact with any of the parties or their people or whatever, and I don't want to. So, in an amended pleading, Lively alleges that this campaign continued after the filing of her complaint. According to Lively, the defendants directly engage with media platforms to overwhelm and confuse the public's understanding of Ms. Lively's allegations and to drive negative sentiment against Ms. Lively and anyone who supports her or speaks out against Mr. Baldoni. Lively further alleges that this campaign involves statements by the defendant's lawyer, Brian Friedman, who regularly issues inflammatory content to media outlets and who says anything, whether true or false, that will harm Ms. Lively's credibility and intimidate others from speaking. Now, the intimidate others from speaking is an interesting aspect here because one of the potential outcomes of this subpoena is to intimidate anybody who might want to speak to the media, like on whatever side, whether they're pro-Lively or pro-Baldoni or whoever they are, right? So Lively alleges that Mr. Friedman's statements were published with actual malice because the defendants know the core narrative advanced by Mr. Friedman, that Ms. Lively fabricated made-up sexual harassment claims to seize control of the film, is false. The defendants allegedly seeded social media content with content creators on online chat sites like Reddit. Reddit's not really a chat site, it's kind of a weird forum mutant. And into publications with small audiences and lax editorial standards. The team would then amplify that content by sharing them with larger publications. Sometimes you see newspaper stories that are like, somebody said a thing on Twitter. That's the sort of thing they're talking about here. Among her claims, Lively alleges defamation and defamation per se by Baldoni and others through their agents, including Brian Friedman, based on their publishing false and defamatory statements about Lively. All right, so now on to Andy Signor. Andy Signor is the founder and CEO of Popcorn Planet, which he describes as a publicly accessible news and commentary channel with nearly 1 million subscribers and a large daily viewership, hosted on Popcorn Planet's designated YouTube channel. You'll note that they have changed the language from news and commentary channel to news network in their press release, right? There's a reason for that. Signor describes himself as Popcorn Planet's main host, investigative reporter, and paid employee. Signor claims extensive experience in journalism and entertainment news reporting. Lively subpoenaed Popcorn Planet for 7 categories of information related to the underlying action. The subpoena called for a response by July 23rd, 2025. On July 25th, Signor moved to quash the subpoena, which he followed with an amended motion to quash on July 29th. Motions to quash, you want to get them in before the required response. Like that's a promptness issue, right? He should have gotten on that right away. In the amended motion to quash, Popcorn Planet argues that the subpoena seeks material covered by the journalist privilege, that Lively cannot overcome the privilege, and that the subpoena imposes an undue burden because Lively could obtain the documents from defendants. Lively responds that the subpoena does not seek privileged material, that even if it does, Lively can overcome the privilege, and the subpoena imposes no undue burden. Note the aspect of overcoming the privilege, because the journalist privilege, at least in Florida, is not like an ironclad wall. There's ways to get through it. It's a protection, but it's not, it's not quite the same level of barrier, for instance, as solicitor-client privilege would be, which is very difficult to overcome and requires something like, crime fraud exception or something like that. So, applicable law, per the rules of civil procedure, requires quashing or modifying a subpoena on timely motion. Timely is going to be an issue here. If the subpoena requires disclosure of privileged or other protected matter, if no exception or waiver applies. So under the rules, a person withholding subpoenaed information under a claim of privilege must 1. Expressly make the claim, and 2. Describe the nature of the withheld documents, communications, or tangible things in a manner that, without revealing information itself privileged or protected, will enable the parties to assess the claim. So this is kind of a finicky thing because you have to produce what they call a privilege log. And a privilege log basically describes all of the documents and describes why they're privileged. And so it might, for instance, say something like, notes of lawyer meeting occurring on date, privileged because of solicitor-client communications, right? These kinds of things. So it has to be sufficient that the person who actually wants the documents can challenge them and can say, wait a minute, that's not privilege covered, right? You have to actually provide those documents. You have to actually, turn it over. So, but you also want to be careful that you're not inadvertently revealing the subject of it. Like in this case, the big thing that you want to conceal and hide and protect is like who your sources are. So you might say something like communication with confidential source, on this date, RE whatever, and you might leave out the RE whatever depending on circumstances, but you got to provide enough detail and description that the other side can say, well, no, that shouldn't be privileged, or can go, well, yeah, okay, they're right, So this echoes the rules of 26b5 and ensures that a subpoenaed non-party witness is subject to the same requirements for claiming privilege as is any party to the action. The party invoking a privilege bears the burden of proving it. So this is the burden of proof, and who has to bring the evidence, right? So it could have been, they could have designed the law such that would have been, Blake Lively's obligation to prove that the privilege doesn't apply. But instead, the law is designed such that Mr. Senior is the one who has to prove that the privilege does apply. So he's got the burden. So a blanket assertion of privilege is insufficient. Rather, a party asserting privilege must establish the privilege for each document withheld. That's why it's got to be a full log, that provides for everything and explains why they're privileged, right? So Rule 501, Federal Rules of Evidence, provides that the federal common law of privilege applies unless the U.S. Constitution, a federal statute, or a federal rule provides otherwise. In a civil case, state law governs privilege regarding a claim or defense for which state law supplies the rule of decision, such as a case arising under 28 U.S.C. 1332. And they quote, Price versus Time Incorporated, state privilege defenses have full force and effect in federal court in diversity jurisdiction. So, however, federal law of privilege provides the rule of decision in a civil proceeding where the court's jurisdiction is premised upon a federal question, even if the information sought is relevant to a pendent state law claim. This is the complicated web of which law applies here. So here, the underlying complaint invokes both a federal question and a diversity jurisdiction, but as to the journalist privilege, the application of either the federal common law standard or Florida law will yield the same result. So deciding between the 11th Circuit and Florida standards is unnecessary. Like, all right, we have to pick between two different sets of rules, except they're both the same rule. So isn't that convenient for us? Yay! The 11th Circuit recognizes a qualified privilege for journalists, allowing them to resist compelled disclosure of their professional news gathering efforts. This privilege shields reporters in both criminal and civil proceedings. And the reason for these privileges is that fundamentally you have there's a social benefit to having news reporting. And sometimes the only way certain things get reported is if people can talk to journalists secretively or at least without being revealed. Because often people who speak to journalists risk reprisals from powerful individuals. One of the fundamental important things about journalism is to hold like politicians to account, wealthy business people, possibly powerful crime figures, and so forth. Journalism really should be holding powerful people to account. I don't know if it always does that now, but that's the idea. And so sometimes the only way these people can speak is if they are protected. So a party can overcome the privilege. Note, there is a way to get over this by demonstrating that the information is relevant and unavailable elsewhere, and that a compelling need supports disclosure. So you can see it's a porous privilege. There's gaps to it. So the standard governing the exercise of reporter's privilege, as articulated in Miller, provides that information may only be compelled from a reporter claiming privilege if the party requesting that information can show that it is highly relevant, necessary to the proper presentation of the case, and unavailable from other sources. So that's the test. And the test basically comes down to, we need it real bad. So it's not an iron wall. It's kind of a wall of cheese. You can push through it if you need to really badly. This standard applies even when the source of the information is not confidential. So under Section 95015 Florida statutes, a professional journalist has a qualified privilege not to be a witness concerning and not to disclose the information, including the identity of any source, that the professional journalist has obtained while actively gathering news. This privilege applies only to information or eyewitness observations obtained within the normal scope of employment and does not apply to physical evidence, eyewitness observation, or visual or audio recordings of crimes. So, like if a journalist picks up a gun that happens to be the murder weapon, they still got to give it to the police, right? The police can still get it. So, and that just makes a whole lot of sense. You wouldn't want a situation where you've got like, okay, we've tracked this down, and yeah, I mean, it kind of makes sense, right? So Section 95015 defines a professional journalist as someone who regularly engages in collecting, photographing, recording, writing, editing, reporting, or publishing news for gain or livelihood, who obtain the information while working as a salaried employee of or independent contractor for, and then this is the key thing, newspaper, news journal, news agency, press association, wire service, radio or television station, network, or news magazine. So you can see why Popcorn Planet's press release is now calling them a network, right? It's like, oh, we've gone from being a channel to a network. And it's not accidental. It's from right here. So Section 95015 specifically excludes from its coverage book authors and others who are not professional journalists. So, if you just post stuff to Facebook on occasion, that's not being a professional journalist. And, you might say, well, isn't this unfair? Well, they get to define the nature of this. Now, when they wrote this definition, I am pretty sure that they didn't think about YouTube existing or the internet existing, because quite frankly, a lot of what used to be television stations are now YouTube channels, right? Or television shows are now YouTube channels. So really, they should include the internet here. I don't know why they don't, but it's kind of an oversight there, right? So, all right. They say, although Section 95015 applies to professional journalists only, the statutory language encompasses journalists working outside of traditional print media. And they note, see Guberev versus BuzzFeed. And they found that an online-only news outlet and its reporters successfully invoked the privilege because the outlet qualified as a news agency, news journal, or news magazine that wrote and published news articles on its website. Now, this is kind of an interesting distinction because BuzzFeed, of course, publishes like articles, written articles, whereas Popcorn Planet publishes videos, much like this one, right? And the court's going to put a lot of weight on that distinction. Similar to 11th Circuit precedent, Section 95015B requires that a party seeking to overcome the privilege show clearly and specifically, 1, that the information is relevant and material to unresolved issues that have been raised in the proceeding for which the information is sought, 2, that the information cannot be obtained from alternative sources, and 3, that a compelling interest exists for requiring disclosure of the information. So that's how, once again, they get through that privilege. Okay. Analysis. Popcorn Planet fails to show that the journalist privilege applies and otherwise waives its claim of privilege. So there's two elements here, and you already notice, as I mentioned before, they said solely because they're a YouTube channel. Well, there's a little more than that. So, Senior formed Popcorn Planet on June 20th, 2022 as a Florida for-profit corporation for the purpose of media production. And then you see this little footnote. And the footnote's right below it. And it says, Senior's declaration claims that Popcorn Planet is a 501c3 corporation, which would be a not-for-profit corporation. Which is interesting because I think he does do it to make money, right? But its publicly available records with the Florida Department of State say otherwise. Judicial notice of these public records is appropriate, and they cite the case law. But yeah, you're not in a good place when the judge says, hey, you're claiming to be a not-for-profit, but you are actually a for-profit according to your filings, according to your records. So that's already a bad place to be, right? He reinstated the corporation on October 8th, 2025 after an administrative dissolution in 2024. Probably some paperwork issue or whatever. Senior claims that he is an investigative reporter and receives a salary from Popcorn Planet. Senior describes Popcorn Planet as a publicly accessible news and commentary channel and himself as the show's main host. Popcorn Planet's channel is an account on the website youtube.com through which Senior publishes content. Senior describes the channel as channel's content as news videos, some of which feature legal experts to comment on high-profile court cases involving celebrities. And then they have a footnote here. The footnote says, Popcorn Planet is little more than a YouTube channel. Although Popcorn Planet maintains a website that operates as an online shop for branded merchandise, Popcorn Planet has no independent website for hosting its video content. Popcorn Planet maintains an online account through the website web service Patreon for fundraising, as well as accounts on other social media platforms such as Facebook, Instagram, and X, formerly known as Twitter. Popcorn Planet's social media links directly to the YouTube channel as its homepage and for its content. Popcorn Planet's content, including any paid exclusive content available through its Patreon or web store, is published and hosted exclusively through YouTube. Now, I don't think it matters much where it's hosted, personally. The court seems to have put a lot of weight on that, and I don't see how that's super relevant. And I think that will be the basis of Senior's appeal here, because he has indicated an intention to appeal. So Senior describes the channel's content as news videos. We just read that. Senior claims that he is unquestionably entitled to invoke Section 9E51 or 5015. It's not a good sign when the court is putting, that quotation there with some sarcasm, right? As well as the common law federal privilege. Senior asserts that Florida courts have already determined that the statutory journalist privilege applies to internet-based entities so long as they report the news. However, none of the cases cited by Senior determines as much or contains significant analysis of the statutory language. And they note Senior's motion contains the wrong citation for Gubarev versus BuzzFeed. The order discussing Section 9015 is Gubarev versus BuzzFeed and citation. In any event, Gubarev is neither controlling nor particularly persuasive on a matter of statutory construction. And as described above, or discussed above, Gubarev holds that Section 9E5015 contains no language limiting the Florida reporter's privilege to traditional print media. Gubarev does not hold that the privilege applies to all internet-based entities that report the news. So this is a bit of a distinction, right? And the court's going to break down the statute, and I think they get it wrong on this point, but I don't know that the appeal is going to be successful, and I'll talk about that. Similarly, Senior claims that he is a professional journalist as defined in Section 905-5015, but again offers no analysis of the statutory language and concludes without explanation that Popcorn Planet satisfies that language. This is the court offering some fairly strong criticisms of Popcorn Planet's arguments, right? And basically they're saying, hey, his lawyer might not have done the best job. Might have missed the mark on the arguing. A wee bit. Or a wee lot. Finally, Senior claims that the content published by Popcorn Planet constitutes news because that content is information of public concern, namely in the categories of entertainment, culture, and current events. To qualify as a professional journalist, Senior must regularly engage in the collection and publication of news while working as a salaried employee or independent contractor for a newspaper, news journal, news agency, press association, wire service, radio or television station, network, or news magazine. And you can see they are sort of pivoting towards network. But they had some problems with this proceeding. They say, yet Senior says nothing about how Popcorn Planet fits within the meaning of those terms. For example, Popcorn Planet concludes without analysis that Popcorn Planet is the type of employer contemplated by Section 9E5015B. However, a YouTube channel such as Popcorn Planet is clearly not a newspaper or news magazine under a plain and ordinary meaning of those terms. Okay, I'd agree with that. I mean, it isn't really. It publishes video. So, they note here, words of common usage when used in a statute should be construed in their plain and ordinary signification. So neither does Popcorn Planet readily fit the term news agency, press association, wire service, radio or television station, or network. That leaves news journal, which also appears to exclude from its plain and ordinary meaning a YouTube channel. Now, and they cite to, the Oxford English Dictionary and Merriam-Webster, etc. Now, one of the things is whether this list is intended to be an exhaustive list or a list of examples. And that's, sort of an issue there. But I mean, I don't disagree with their, their current tack of saying we're a network. Network, fair enough. I can see it. I could also argue that television station shouldn't be understood as being limited to strictly television as has been sort of envisioned, but should also include internet programming that is similar to a television station, such as many YouTube channels. So even if Popcorn Planet could muster a definition broad enough to cover its YouTube channel, any interpretation must consider the context in which the term appears. Section 9E5015 is precise and clearly intended to exclude certain types of media, as evidenced by the exclusion of book authors and others who are not professional journalists. But I mean, Andy Signor does make his living doing this, right? I don't think he's got a day job. I think this is his entire thing, which suggests that he is kind of a professional, right? He's devoted himself to this. It's not like that this is sort of him being a piker or anything like that, So the definition of professional journalist includes within its scope professional news organizations, which are distinguished in part by the exercise of editorial standards and control. So this is something that is often touted. Now, the thing is that networks don't necessarily behave any better than YouTubers. It really depends on, I guess the specific YouTuber, but some people some YouTube channels, I would say, follow a higher ethical standard than your average news organization, and some less so. So nothing submitted by Popcorn Planet suggests that its show practices the editorial standards normally associated with a professional news organization. I suspect they probably just didn't think that was going to be something the court hung its hat on. And so they say, see, e.g., Statement of News Values and Principles, and, Editorial Standards and Ethics Guide, Standards and Policies for the Daily Wire, Editorial Policy for People Magazine. Okay, so maybe I need a policy. But furthermore, although Signor investigates entertainment news and creates content, his position at Popcorn Planet is not the type contemplated in the section. Signor says that he's employed by and receives a salary from Popcorn Planet. But he's also Popcorn Planet's owner, founder, and CEO, the host, director, editor, and main producer, as well as the registered agent of the company, the addresses for which consist of a U.S. Postal Service mailbox and a private residence, according to the Florida Department of State. So basically they're saying, yeah, it contemplates being an employee, and really you are employed by yourself as a corporate, tax financial vehicle. But Popcorn Planet isn't much more than you, is what they're saying. Thus, Signor is self-employed, and Florida courts have historically held that the journalist privilege applies to journalists employed or hired by traditional media outlets. So this is, again, they're saying, well, and this isn't necessarily that a YouTube channel couldn't meet this aspect of that sort of test, but they're saying he doesn't. And to be fair, a lot of YouTube channels wouldn't, according to this. So, and they cite to Tectronic Indus versus Victor Bonilla, finding that self-employment is clearly not contemplated in the statutory definition of a professional journalist. Okay. Now, again, I feel like this statute is out of date and needs to be updated to include how journalism happens now, because some people who do really good journalism are on their own and publish entirely to, YouTube or to a Substack or something like that. So additionally, as explained during the first hearing on Popcorn Planet's motion, whether the privilege applies depends not only on whether Senior is employed as a professional journalist, but also whether he was engaged in news gathering at the time that he obtained the information. Even if Senior is employed as a professional journalist within the meaning of the privilege, Senior is not necessarily engaged at all times in professional news gathering, in the same way that a lawyer is not always engaging in attorney-client communications or working in anticipation of litigation. So, there may be things that lawyers do with their client that might not be privileged. Like, we went and grabbed lunch. Did you talk about the case? No. Okay. Senior cannot assert a blanket claim of privilege over his activities, but rather must assert that privilege on a document-by-document or item-by-item basis, as would any other holder of a constitutional or statutory privilege. And here's where they're going to say, listen, even if he has the privilege, he screwed up and waived it. This is kind of the argument, is like, even if he's got the privilege, he screwed up and blew the privilege up. So it's, again, not just because he's the YouTuber, but they're saying even if he wasn't, even if he was working for the New York Times, he's in the soup here. So instead, an attorney must present himself with his records for questioning, and as to each record, elect or to raise or not to raise the defense. So you've got to go document by document, right? If you've sent back and forth with your client 150 emails, you got to go through 150 emails and say, is this one privileged? Is this one privileged? Furthermore, Rules 26 and 45 require a timely and express claim, as well as a disclosure of information sufficient to support his claim. And you remember, they said that he delayed. He didn't get back to them until after the expiry of the subpoena. So here, Lively served the subpoena on July 3rd, and Popcorn Planet moved to quash on July 25th, 2 days after the time required for compliance. As of October 22nd, Popcorn Planet had not produced a privilege log identifying responsive but privileged documents, and had not sought an extension of time in which to do so. So, October rolls around, they still haven't done what they have to. After requiring the parties to confer about the scope of the search for responsive documents, on October 31st, Order Document 21 required Popcorn Planet to produce a privilege log no later than November 5th. Court's like, you got to produce this. Popcorn Planet moved for an extension of time and attached a preliminary privilege log to its motion. During a November 7th status conference, I explained to Popcorn Planet that the privilege log was inadequate. The judge is like, I told you you were screwing up. And you continued to screw up even though I told you to stop it. For example, in one entry, the log identifies a text string spanning from January 1st to June 24th, 2025. That's a long time. That's like 6 months. So the description, that entry, along with every other entry, is a vague conclusory statement essentially saying that the item is privileged, which provides little basis from which to evaluate the claim of privilege. Who's he texting from January 1st to June 24th? Well, Blake Lively's going to find out. So, yeah. In response, counsel for Popcorn Planet argued that it was nonsense or absurd to suggest that he had to log or itemize each and every text message subject to the privilege. The court is going to find that it's not nonsense or absurd. So, compare Johnson, explaining that when opposing counsel noted that Mr. Froelich had not provided a privilege log or attempted to parse out the communications that would be privileged, Mr. Froelich replied, I don't parse it out. That's not my job. Consistent with counsel's position that the law does not require particularity and that Popcorn Planet can claim the privilege categorically, the final privilege log filed by Popcorn Planet contains no changes except for the addition of 2 items. Counsel for Popcorn Plant. That's an interesting typo. They dropped the E, but wouldn't be caught by spell check because plant is totally a word. So Popcorn Plant is incorrect on the law, and he fails to show that the subpoenaed communications were privileged. So, whoops. Court's like, yeah, you're wrong, though. So, Popcorn Planet produced no privilege log until ordered to do so 3 months after receiving service of the subpoena. Thus, Popcorn Planet failed to timely provide a privilege log, and despite repeated opportunities to correct this omission, the court's like, I told you you were screwing up. I gave you every chance to fix it. You didn't fix it. So you fucked around. Now's find out time. So, failed to produce a privilege log with sufficient particularity to assess the privilege claim. This results in a waiver of the privilege. So the court is saying even if they have the journalist privilege, their actions by failing to produce a proper privilege log waive it and cancel it out. So, yeah. When a party when a party provides an inadequate or untimely privilege log, the court may choose between 4 remedies. 1. Give the party another chance to submit a more detailed log. The court's already done that. 2. Deem the inadequate log a waiver of the privilege. The court is doing that now. 3. Inspect in camera all of the withheld documents. We can see that they did that previously. And 4, inspect in camera a sample of the withheld documents. So the court's got a range of choices, right? And they cite to another case, finding that a waiver of privilege because, among other things, the privilege log does not provide sufficient information to assess the claim of privilege. And Mosley versus City of Chicago, finding that a journalist's failure to produce a Rule 45 compliant privilege log waived whatever claim of privilege she had. You'll see the trend here. There are prior cases that say if, even though somebody's a journalist, if they fail to follow these rules, they lose the privilege. And that's where Andy Signor and Popcorn Planet are. So the burden of the party withholding documents cannot be discharged by mere conclusory or ipsy-dixit assertions. So an in-camera review of the documents is included in the privilege log, demonstrates the problem with Popcorn Planet's generic and conclusory privilege log. So what that means is that the court took the actual documents that privilege was asserted on and looked at them privately, right? Just on their own, without showing them to anybody to say, like, okay, are these actually privileged? For example, item 4 on the privilege log is a 6-month-long, 89-page text message conversation between Signor and a defendant in the underlying lawsuit. Gee, I wonder, who could that be? Yeah. That's real bad, too. That's getting given up. I bet that defendant, that mystery defendant, is real pissed that this is happening, especially given the court's finding that it's Signor's fuck up here that is resulting in it. So, notwithstanding his claims that it's just because he's a YouTuber, it's not just because he's a YouTuber. So, as one would expect, the conversation contains some information that is clearly irrelevant, unresponsive, and not privileged. And so the proper thing to do is to break that down and say, this is a non-responsive to your subpoena, so we're not disclosing it on that basis. It's relevant, right? The text message conversation constitutes the bulk of the material in the initial privilege log, which contains a mere 142 pages. Yet the log nowhere specifies the number of individual messages, pages, or specific exchanges to which the privilege allegedly applies. The final privilege log contains only 2 additional items, which suggests the final universe of documents is not much longer than 142 pages. Thus, Popcorn Planet cannot plausibly claim an undue burden in having to separate these documents into their relevant and purportedly privileged parts. Of course, it's 142 pages. That's not even a long novel. You can take the time, you can split this up. This isn't, when is the court going to find that it's an undue burden? Well, let's imagine you're like a single parent and, you don't have much time to spare and it's thousands of pages. this would be 10,000 pages that I have to go through. How do I go through 10,000 pages? Court might have sympathy there. They're not going to have any sympathy for 142 pages. 142 pages is not a lot of material at the end of the day. Even if the inadequate privilege log caused no waiver, Popcorn Planet's production of documents has. I'm pretty sure I've actually read more than 142 pages worth of material today. And I mean, it's been a busy day, but today. So even if the inadequate privilege log caused no waiver, Popcorn Planet's production of documents has. A comparison of documents included in the in-camera inspection with those produced to Lively reveals no discernible substantive difference. Items 5 through 17 and 19 are inquiries by individuals associated with Popcorn Planet seeking comment from people involved in the film, who provided no substantive response. So, hey, Joe the Grip, we would like a comment. What did you see? And Joe the Grip is like, go away, not interested. Okay, or just doesn't respond. So these emails are similar in content and character to the emails produced by Popcorn Planet to Lively. Yet Popcorn Planet provides no information about why some inquiries are privileged and other similar inquiries are not. Accordingly, I find that Popcorn Planet fails to establish that the items responsive to the subpoena are protected from disclosure under the journalist privilege. But then they go on and they go into even if the privilege applies, which they've already concluded for 2 separate reasons it doesn't, Lively still gets the documents. So even if Popcorn Planet established the items sought by Lively fall within the journalist privilege, Lively can overcome it. The requests in Lively's subpoena are directly relevant and material to her claim that the defendants in the underlying action orchestrated a campaign to defame her with the help of third parties who created disparaging and false content. Furthermore, an in-camera review reveals that the responsive materials are directly relevant and material to Lively's claim. Now, this is interesting because this actually raises the possibility that we could see an amended complaint that adds Popcorn Planet to the suit. I don't know what the odds are of that, but it's possible. And that could be interesting. If that happens, it'll be very expensive for Popcorn Planet. So Lively further establishes that she tried to discover this information from the defendants and to some extent has been unable to obtain these materials from them. Lively demonstrates a compelling need because these materials go to the heart of the matter, that is, the primary theory underlying Lively's defamation claim. So, and they cite to Carroll versus TheStreet.com, explaining that Florida law and the 11th Circuit direct courts to pierce the journalist privilege in libel cases when a journalist is the defendant and where a plaintiff's need for the information goes to the heart of the matter. So, again, they're saying the law allows them to push through the privilege even if one existed. See, the subpoena imposes no undue burden on Popcorn Planet. Popcorn Planet argues the subpoena imposes an undue burden because the subpoena seeks extensive document production and because Lively has not exhausted more direct avenues to obtain the requested information. 142 pages is not going to be considered generally extensive document production. Extensive document production is when you start talking about many, many bankers' boxes, yeah. So this argument fails for several reasons. During the first hearing on Popcorn Planet's motion to quash, counsel admitted having not discussed the scope of the requests or the attendance search with counsel for Lively. When given an opportunity to raise objections to the scope of the requests in the subpoena, counsel for Popcorn Planet says, "I don't have a problem with the scope," and affirmed that his only concern was with privilege. So, waived scope issues. And scope is is it overbroad? Is it seeking, are they asking? Sometimes you'll see subpoenas that say we want every message you've ever sent to any person. And then you're like, the scope of this is insane because it's clearly going to get stuff that that it is irrelevant, right? You know, Andy Signor's messages to his mom or, his house cleaner or whatever are not going to be relevant here. But they said, we don't have a problem with the scope. So scope it's settled, it's waived, it's done. So second, although the undue burden analysis under Rule 45 considers whether the materials are available from another more convenient source, nothing in Rule 45 requires a party to exhaust all other sources of information before pursuing third-party discovery. So, sure, they should try to get it from the parties first, but they don't have to necessarily get it from the parties, especially if there are roadblocks. Even if required, Lively has attempted, unsuccessfully, to obtain the same communications from the defendants in the underlying case. So we tried. They wouldn't give it to us for whatever reason. Accordingly, Popcorn Planet fails to establish that the subpoena imposes an undue burden. Accordingly, the amended motion to quash, Document 2, is denied, and the initial motion to quash is denied as moot. No later than December 17th, 2025, the movement Popcorn Planet must produce all responsive material to Lively, including every item contained in Popcorn Planet's privilege log, as well as the attachments to those items. To the extent necessary and not already covered by an order on the underlying action, the parties may propose a stipulated protective order governing the handling of this information. Okay, so when we go back to the statement here, you can see the statement made says that a federal magistrate judge in the Middle District of Florida has denied journalist protections to Andy Signor, founder of the independent news network Popcorn Planet, solely because his reporting appears on YouTube rather than in traditional corporate media. Again, the solely doesn't appear to be made out here. In fact, they said, first, we don't think you're a journalist. But second, if you are a journalist, you blew up the privilege by, not following the rules. And even if you didn't blow up the privilege by not following the rules, she'd be able to get through the privilege anyway. So all of this matters for his appeal because he said he wants to appeal. I think he's got a much better argument on the issue of, is he a journalist? I think the court should say, well, yeah, he's a journalist and this is being interpreted overly narrowly. But I think he may have a hard time on the other issues. And so the appellate court may say, listen, we don't care about your issue of whether or not you're a journalist because we agree that even if you're a journalist, you blew up the privilege. Sorry, too bad, so sad. Give over the documents. So whoever this mystery individual, mystery defendant that he apparently had many, many communications with, they're probably gonna tell him to lose their phone number. So yeah, that is what it is. And we'll see what happens. But I was curious about this one because I saw wait a minute, they found that YouTubers can't be journalists, but that's not really what they found here. They found that in this specific case, this specific statute doesn't apply. I don't think that I think they're applying or interpreting it overly narrowly, but a lot of this sort of rhetoric I've seen online doesn't appear to match up with the actual order. So the actual order seems to put, a lot of weight on Popcorn Planet sort of failing to provide a privilege log. And that may ultimately be what defeats him in this one, especially if an appellate court goes, well, yeah, they did give you more time. They did warn you that your privilege log was insufficient. They did caution you. They did examine the documents. They gave you every opportunity ahead of time, and you still blew it. Anyway, so those are my thoughts on this one. I'm probably not making any friends here, but it is what it is. Yeah. But thank you for watching. I hope you found this one to be interesting or educational. I will probably not do extensive coverage on Lively v. Baldoni because I don't like Lively and I don't like Baldoni. At the end of this, I mean, that doesn't mean that I consider them on equal footing at all. It's just that, like, I mean, one of them, seems to be a lot more horrible than the other. And but that doesn't mean that I like the other either, right? So, yeah, I don't know. The way you see like Hollywood folks talking to each other in that, the sort of flowery language where everything is like blowing smoke up each other. I just can't stand it. It's giving me like, some sort of poisoning. And so I'm probably not going to cover this one extensively, but I'll cover things that happen in it that are interesting to me, because that's really how this channel works. I talk about stuff that interests me and that I hope interests you as well, but yeah. Anyway, thank you for watching. I hope you found it to be interesting and potentially educational. I also want to thank my Patreon supporters. There's a link to that in the description below, as well as below you can find all of the like, subscribe, all of those good buttons. Hit the buttons. And at the $50 level, Bottle Shock and Oz, Canada's National Farms Association, PJ's Forever, Canadian Coalition for Firearms Rights, Canadian Shooting Sports Association, Kyle Fox, Angela Skelton, Purple Dragonair, Cielo, Shay B, and Johan/Phoenix. And at the $20 level, Marvin CZ, Cameron Johnson, Larry Kalniak, Andrew Elsich, Mark, and Drunk All of the Baileys. Thank you as well to the $10 supporters and the crawl following. And thank you for watching. See you next time.